and before the Senate. But because of the timelines we've given you, my lords, it is not a matter of public emergency. But having found herself in that situation, she decided to treat this matter as one of public emergency. Then, my lord, she directs come and sit on Saturday. We have set out in our applications and in our affidavit. There must be certain circumstances under our laws, the High Court Administration and Organization Act, that can justify for any bench to sit outside on Saturday and Sunday. There must be express reasons. Those express reasons, as we sit here, are grieved. We still do not know them. And if we do not know them, every Kenyan who would be aggrieved by a decision made in these circumstances would have every reason to be concerned that from the word go, there was a conspiracy to commit injustice. My lord, all of you have been honorable members of the High Court. There cannot be, where there is no public emergency, for occasions to arise that for the first time you would effectively be accused. You engaged yourself in a conspiracy to undermine the constitutions and to defeat it in a manner that would amount to treason. So that, my lord, the point that we make is that in the absence of a public emergency, what has so far happened is not only just unconstitutional, but something that would amount to violation of the Constitution and something that would amount to violations of the Penal Code as far as the issue of observing justice is concerned. My lord, for argument's sake, we proceed to make that argument. Let's assume that there was an emergency. We submit there was none. But let's assume there was one. If there was an emergency, then it was incumbent upon the Chief Justice to read, and they were in the newspaper and in the news, all these cases that honorable judges of the High Court from various stations had recommended for a bench to be appointed to hear them, to consider them, and place them for hearing on Saturday, and to fast-track that hearing. But, my lord, what is it that happened? My lord, what actually happened is that you have a situation whereby the respondents, who are basically agents of the government of Kenya and its various appendages, have gotten their applications to be satisfied and for a bench to be specially convened to sit, because from the standpoint of the petitioner, to set aside the conservatory order in order, as the petitioners contend, the violations of the Constitution may be completed. My lord, justice in this case, if it means anything, it must mean a very simple issue. The multiple violations of the Constitution that are already ingrained and embodied in the various applications, we cannot allow them to be completed, because this is what it's all about. This is what the decisions of the Chief Justice was all about, to complete the serious violations of the Kenyan Constitution. By your oath of office, your lordships are committed to stop a respondent and the government and its appendages that act in this manner. My lord, what does it amount in law for the Chief Justice to say you have about 15 or 20 cases, as I hear from my learned colleagues who have been in this matter longer than me? I'm here today for this matter, and I'm here because there is a constitution in Kenya. My lord, that being the case, there has to be satisfaction. If the Chief Justice, and she's a party in this application, cannot be able to justify why did you choose to address the grievances of the Attorney General and the government of Kenya and leave the petitioners. The first right of hearing under our Constitution, I deal with Mutunga rules every day, is that the petitioner will have their rights to be heard, to prosecute their case. That is what the Bill of Rights means. The respondent, even under Mutunga rules, will respond and answer the allegations that have been made. But, my lord, where the Deputy Chief Justice chooses to fast-track the grievances of the alleged violator. Common sense has to be affected. My lord, the conscience of this court must be bothered. Such conduct in the normal sense of things. We went through the removal of judges during those days. There was just minor infractions of the right to be heard, and judges were shown the door home. But my lord, here it is a systematic decision consciously made that would have very harmful effect for the jurisprudence of our country and for the meaning of our constitution. So that my lord, so that my learned friends can be able to speak for themselves, we are alleging that as long as the bench has been appointed by the Chief Justice, who has declined to follow the fair process for purposes of appointment of the various judges to sit, there cannot be a valid appointment. Not because I and my colleagues here would have anything on a good day before any of you, your lordships. We have done very many matters. You have courageously stand up for the constitutions in various matters. But my lord, unhappily, we have to be the ones saying that it would appear to a section half of this country, if not 3/4, that you have been enlisted in service of the violations of the constitutions. My lord, that may not have happened, but that is the only way reasonable people would be able to interpret all this, particularly against the background that even the Gen Z were abducted. The substantive Chief Justice did not empanel a single bench to sit on Saturday or on Sunday. That is why but the context in which this matter must be viewed. My lord, there are certain authorities. My learned colleagues will go through them. But I need to mention at least two things. My lord, of course, the arguments would be made. I think there was some time back, probably in the Okiya Omtata case, my learned colleague will clarify, where the Deputy Chief Justice, the same Deputy Chief Justice, made an appointment. There was no substantive Chief Justice at that time. There was a decision that was saying this is administrative. That decision is not binding. But my lord, more importantly, now that this issue is arising directly, this court must retire, make a very reasoned decisions to settle this issue. Whether in every other case in which the constitution or statute says so and so will do this, if that so and so does not do it, without failure, the High Courts and the Court of Appeal have always held there was no jurisdiction. An order of certiorari have always issued. It shouldn't be different in this particular matter, because the power belongs to the Chief Justice. Now, the second issue is a decisions, I believe, one of you was involved, and which is that case? I believe it is a case of Okonkwo Omtata versus JSC, and the decision in that decision was that at paragraph 29 to 38, basically it says that where there is a substantive Chief Justice who is a state officer, she does not cease to be a Chief Justice in this era of technology. And accordingly, the Chief Justice, the CJ, does not have authority under the constitutions to assign roles assigned to that office. So that, my lord, in this case, even assuming that in writing the Chief Justice had assigned this role to the deputy, and that has not been alleged, it would still not be good enough, because wherever that the good Chief Justice might be, this is something that she could have done as expected her. And the people of Kenya obviously would be interested because of the nature of this matter. Why would the Chief Justice abdicate to do her job and let her deputy to do her job in a manner that aggrieves the petitioners? That is an important question, because it is the job of the Chief Justice. There is a huge mandate that is given by the Chief Justice. Do your job with the entire authority that your office carries. So it cannot just be that it is for the Deputy Chief Justice who has usurped. It is also abdication. What would be the basis for abdication? The Chief Justice not to do their job. The other case of, just 1 minute, 1 second. The other case of, I think my learned colleagues, so that it can be fast, I don't want people to knock me. My learned friend can, do have it. Let him do his 10 minutes, then he can do his 10 minutes.
Thank you. Thank you very kindly, my lords, my lady. I'll only highlight a few issues which are legal. I'll move from Article 1 of the Constitution, your lordships. That Article 1 has created organs of government. Among them is the organ of the judiciary. And it has clearly provided, your lordship, that the people of Kenya, in exercise of their sovereignty, they have delegated their powers to those organs. In this case, the power under Article 165, Clause 4, is exclusively delegated to the Chief Justice. Your lordship, in administrative law, it's right that a person who enjoys delegated powers cannot further delegate those particular powers. In this case, in this circumstance, your lordship, it is not known to the petitioners under what circumstances the Chief Justice may have delegated these powers to the Deputy Chief Justice. It is our humble submission, your lordship, that the powers and the functions under Article 1 are not capable of being delegated. Further to that, your lordship, you seek leave under Article 159 of the Constitution, which provides that, your lordship, that judicial power is derived from the people and shall be exercised by the courts and tribunals established by this Constitution for and on behalf of the people. That article, again, clearly indicates that this power under Article 165, Clause 4 is not capable of being delegated. How about, your lordship, in the Constitution? Your lordship, I invite you to look at Article 260 of the Constitution. It provides if a function has been created to be executed by a particular organ, it is only that organ that is capable of executing that particular function. And for the question of further delegating that particular function cannot arise so as to say that the Deputy Chief Justice had the constitutional mandate to appoint this bench to adjudicate over these particular files. Your lordship, we have put up a case that the Deputy Chief Justice has not only violated the Constitution, but also violated the rights of the petitioners to be heard under Article 50 of the Constitution. When they moved to appoint a bench of this, the bench, and failed to notify the parties herein as evidenced by the counsel appearing for the petitioner in petition number 14, it tells your lordship that the expediency for which it was done was so as to meet the objective of setting aside the orders that were granted by your brother Justice Mwongo and your brother Justice Mwita. Your lordship, when you retire to make a ruling of our application, it is important that you pay serious attention to paragraph 12 of our affidavit, paragraph 21 again of the affidavit, paragraph 22 again, and also paragraph 27. And then you might want to ask yourself, under section 10 of the High Court Organizations, High Court Administration Organization Act, how, under what circumstances, the Chief Justice, the Deputy Chief Justice, authorize you to sit on a Saturday? Under what circumstances did the Chief Justice herself, Deputy Chief Justice herself, sit at night, in the wee hours of the night, ungodly hours, and constituted this bench? Your lordship, it's our humble submissions that Article 10 has only arrogated that function, again, exclusively to the Chief Justice. And that the Deputy Chief Justice has no power under Section 10 of the High Court Organization and Administration Act to order you or to authorize you to sit on an odd day like that or the Saturday. Your lordship, permit me to draw your attention again to the case of Omtata, When you retire and the judgment will be highlighted by my learned friend, it is of importance, Your Lordship, that you look at paragraph 192 of that judgment. It has given the circumstances under which the Deputy Chief Justice can act in the absence of the Chief Justice. One is if the Chief Justice is indisposed, if he resigns, if he is dead, or if he is voted out of office. The question of leave, to which we are submitting without knowledge whether that is the circumstance that led to the allocation of powers by the Chief Justice, is not one of the grounds or reasons that the Chief Justice can exercise, the Deputy Chief Justice can exercise the exclusive powers meant for the Chief Justice. Finally, Your Lordship, all these averments contained in our affidavit have not been controverted by the respondents through a replying affidavit. They have only filed the grounds of opposition, to which they shall bring to your attention the case of Conchela, which has been distinguished by the case of Okia Omtata. The grounds contained in our affidavit, Your Lordship, are uncontroverted and they must be admitted as such. I beg to rest my case.
Specific reference to Okio Matata has been mentioned by two counsel. He's probably the most prolific litigator in the history of Kenya, so we don't know which of his many cases are you referring to.
I will certainly be addressing my senior at the bar and senior at the academy, Professor Gideon Mugai. It's always a pleasure being with him in court. A man or woman who plants a tree, not knowing fully well that they will not sit in its shade, knows the meaning of life. You sit today in such an epochal moment that what you do here has significant ramifications for the Republic of Kenya. It is for you and the court to rise to the occasion. This court has defined the Constitution as a transformative constitution. And this was done by this very court, differently seated in the BBI case, David Ndi and others, versus the Attorney General. And this is what the court said about the Constitution 2010. It is a constitution of a transformative character. And this transformative character of the Constitution induces large-scale social change, including the character and conduct of politics. That the Constitution bears an internal theory of interpretation. The starting point for discerning that internal theory is Article 259 of the Constitution. That formalistic approaches to constitutional interpretation are not favored. And lastly, that the Constitution has provided for its own theory to protect its values, objects, and purposes. That is what is before you as a court today, that you are supposed to maintain that innate character of this Constitution as a transformative charter. The other side has filed grounds of opposition, and in their grounds of opposition, they raise a case, Lorna Conchela and others versus the Chief Justice. That was the grounds of opposition by the Attorney General. And in that case, this High Court said that the power to appoint a bench is administrative, and that that power can be performed by the Deputy Chief Justice in limited, constricted circumstances. That the normative holder, the Chief Justice, performs it, but the Deputy Chief Justice has to perform it in certain limited circumstances. those limited circumstances have to be demonstrable. That is Conchella. Your Lordship, Justice Murima, sitting in Okoiti versus JSC and another petition, E408-2020, 2021 EKLR, I believe that is what Professor Guido Muige was asking about. Paragraph 29 to 38. Justice Murima finds that the authority under Article 165.4 is a constitutional authority, such that that authority cannot be delegated by the Chief Justice, because the Chief Justice does not cease to be a state officer, even on leave. We have another authority here, Petition 31 of 2013, Kenya Medical Research Institute versus the Attorney General. This is found at 2014 EKLR at paragraph 37. Kenya Medical Research Institute versus the Attorney General and three others, 2014 EKLR. This case at paragraph 37 says this, that the Chief Justice under Article